Welcome back to the Deep Dive. Today, we are opening a file that, honestly, it's a nightmare scenario for anyone who's ever bought a home, or for that matter, anyone who sells them for a living.
Oh, absolutely. It's a topic that keeps real estate agents up at night.
And it makes home buyers, the hesitant ones, sweat right through their sheets.
Mhm.
We're looking at this high-stakes tension between a signed binding contract and this legal escape hatch called the attorney review clause.
It's a really fascinating area of law. It sits right on the fault line between two major legal ideas.
Go on.
On one side, you have the sanctity of a contract. Once you sign, you're bound. That's the whole point. But on the other side, you have the protective role of your lawyer. And in real estate, those two things just crash right into each other.
And that crash, that's the hook for today's deep dive.
Yep.
So here's the question. If you sign a contract to buy a house, the ink's dry, you've shaken hands, you're mentally placing furniture, can your lawyer just call it off the next day because they don't like it? Or do they need to find a specific technical legal reason? Like a problem with the title or a zoning issue.
That is the million-dollar question. Does the lawyer have carte blanche, a total blank check to kill the deal, or are they limited to, strictly legal objections?
To answer that, we're doing a deep dive into the scope and effect of attorney approval clauses.
And to navigate this, we're going to follow a very specific path. We're going to focus our whole discussion on one key case, the seminal New Jersey case Indoe v. Dwyer.
Okay.
This one is the absolute gold standard for understanding this entire issue.
All right, before we get to the case facts, give us the roadmap. What are the big legal concepts we need to get our heads around here?
Okay, we're going to be looking at the difference between objective standards, think marketability, and subjective standards, which are all about personal satisfaction.
And that distinction is what matters.
It's everything. That distinction determines whether you're actually under contract or if you just think you are.
Okay, let's unpack the tool itself first. We see these clauses everywhere. What exactly is the legal function of an attorney approval clause? Does it just make the contract voidable whenever you want?
So generally speaking, an attorney approval clause creates what we call a condition subsequent.
Condition subsequent. Okay, that sounds like pure law school jargon. Break that down for us.
Think of it like this. The contract is binding the moment it's signed. It's a real living contract.
Okay, not a maybe.
Right. It's not a letter of intent. But its continued life is contingent upon a future event, the lawyer's approval within a set time. If that approval doesn't happen, the contract terminates.
So it's a valid contract with a self-destruct button built in.
Precisely. It's valid until it's voided. And for that self-destruct button to even be active, we generally look for 4 specific elements in the clause.
What are they?
First, valid execution of the contract, obvious but necessary. Second, a specific window for review. In our case today, it was 3 business days.
Yeah.
Third, and this is key, there's often a limitation on the scope of the disapproval. You'll see clauses that say the lawyer can't object to the price or the financing.
Okay, and the fourth?
The standard of review, which is always, always good faith.
That seems straightforward on paper, but it feels slippery,
Right.
especially that scope part. So we're going to use Indoe v. Dwyer to really test this. But before we get to the facts of that case, I want to try a hypothetical. I really want to nail down this difference between an objective standard and a subjective one.
That's a great idea. It's the best way to see the real-world stakes here.
Okay, here's the scenario. A buyer signs a contract for a house.
Right.
It's a done deal. But the next day, they go back and, they realize the basement smells faintly of old cheese.
Okay.
Or they just get a bad vibe. Like they think the house might be haunted.
Yeah.
Now, to be clear, there's no structural defect. The title is clean. Can the lawyer kill the deal over the cheese smell or the bad vibe?
This brings us right to the core of it. In contract law, with these satisfaction clauses, we have 2 ways to look at this.
Let's do the first way.
The first is the objective view, or the marketability standard. This is what's usually applied to things like title or structural integrity. So if we apply this to your cheese scenario, the buyer must close the deal.
Why?
Because a bad vibe or a cheese smell doesn't affect the marketability of the title. If the title is legally valid, no liens, clear ownership, the lawyer can't disapprove just because the client has cold feet. The dissatisfaction has to be reasonable to a prudent person.
So under the objective view, if a prudent person would buy the house, you're stuck. Your personal quirks don't matter.
Exactly. You're held to an external standard. But the alternative is the subjective view. This is based on trust and satisfaction. The idea here is that the parties didn't just bargain for a house. They bargained for the attorney's personal satisfaction with the deal.
So the lawyer becomes the ultimate decider.
Yes, the attorney is the sole arbiter. Under this view, even if the title is perfect to the whole world, if that specific attorney is dissatisfied, as long as they're acting in good faith, they can kill the deal. It doesn't matter if the objection seems totally unreasonable to everyone else.
And Indoe v. Dwyer is the case that tells us which of these two standards applies to the entire contract, not just the title.
Correct. It settles whether your lawyer needs a good reason or just a reason.
Let's get into the case then. We'll use our structured analysis. Let's analyze Indoe v. Dwyer. First, what are the legally dispositive facts?
Okay, so the plaintiffs were William and Jane Indoe, the sellers. They listed their home in Bernardsville. The defendants were John and Christine Dwyer, the buyers.
And how did the transaction go down? Was it just a standard deal?
Not quite, and this context is important. The husband, John Dwyer, was away on business. Mrs. Dwyer saw the house. She liked it. She offered $225,000. The realtor then drew up a standard form contract, and Mrs. Dwyer signed it.
Okay, so far so good.
But here's the kicker. She thought she was just signing a bid or an initial offer. She assumed a formal contract would be drafted later with her husband and their lawyer, but the sellers signed it that same night.
Whoa. So she thought she was opening a negotiation, but she actually signed a binding deal. That's a huge disconnect. What did the contract say about the lawyers?
It had a typed clause making the contract contingent on attorney approval within 3 business days. But it had an exception. The attorneys could not disapprove based on price and financing terms.
That's a common carve-out. They don't want lawyers just retrading the price. What happened next?
Within that 3-day window, the Dwyer's attorney called the realtor and said he disapproved of the contract.
Did he give a reason?
Nope, no specific reason, just disapproved. The Indoes, the sellers, were, as you can imagine, furious. They sued for breach of contract. Their argument was basically, you can't just say no, you have to tell us what's legally wrong so we can fix it.
I get their point. It feels like they're just backing out. So what was the core legal issue for the court?
The issue was this. Does an attorney approval clause grant an attorney an unlimited right to disapprove the contract? That's the subjective standard. Or does the disapproval have to be based on reasonable, specific legal problems, the objective standard?
And what rule of law did the court apply? Let's get the full black letter rule here and break it down into its testable elements.
Okay, the court established this rule. A general attorney approval clause allows an attorney to disapprove a contract for any reason, subject only to a standard of good faith. It makes the attorney the sole judge of their own dissatisfaction.
That is incredibly broad. What are the elements of that rule?
We can break it into 3 pieces.
Yeah.
First, contractual stipulation. The clause has to actually be in the contract.
Right.
Second, subjective discretion. The attorney's judgment is final. It doesn't have to be reasonable by objective standards. And third, good faith. The disapproval can't be arbitrary, capricious, or in bad faith.
Arbitrary or capricious. Feels like it's doing a lot of work there. Let's dig into the court's reasoning. Thank you. Now for the court's elemental analysis. Let's go step by step. How did the court apply that first element, the distinction between objective and subjective standards?
This was the first major battle. The sub-issue was whether the court should use that marketability test, the objective one. The sellers argued, look, if the title is good, the contract is good. In its analysis, the court just flatly rejected the idea that the attorney must give valid and reasonable objections. The reasoning went back to another case, Sanger v. Sladen. The court said that applying an objective standard denies the buyer the whole benefit of having their own lawyer's judgment.
Wait, pause on that. Why does it deny the benefit of counsel?
Because if your lawyer says no, but a judge says, well, a reasonable lawyer would say yes, then you're being forced to accept the court's judgment over your own lawyers. You hired your lawyer for their specific subjective caution, not for a generic rubber stamp. So the conclusion on that element, the court adopted the subjective approach.
Understood. Now, what about the second element, the scope of that specific clause, the one that said, except as to price and financing?
Right, this is where it gets really technical. The sub-issue was whether that exception limited the attorney's power to disapprove generally. The plaintiffs argued that since price was excluded, the lawyer had to point to a different deficiency.
That seems logical. If I say, you can review everything except X, and you just say no, how do I know you're not secretly rejecting it because of X?
The court didn't buy it. In their analysis, they looked at the exact wording. The clause bound the parties to the opinion of the attorney on the efficacy of the contract. The reasoning was that as long as the objection wasn't explicitly about price, like a letter saying, I disapprove because my client wants it for $5 less, then the attorney's judgment is absolute.
So for the lawyer, silence is golden.
In a way, yes. The exclusion for price didn't suddenly force the attorney to provide a legal reason for rejecting the rest of it. So the conclusion for that element was that the exclusion clause didn't change the standard from subjective to objective.
Okay, and the third element, the policy justification. Why does the court allow this? It feels like it puts the seller at a huge disadvantage.
The court addressed that directly. The sub-issue is why public policy would support this broad power to cancel. In its analysis, the court emphasized that real estate contracts are complicated, they fix fundamental rights.
Sure.
The reasoning centers on the idea of the trusted counselor. The court recognized that people, like Mrs. Dwyer, often sign these things in a hurry to lock down a deal. There's pressure.
It prevents them from being trapped by their own haste.
Exactly. The purpose of the clause is to let you sign now but still get proper legal advice later. If you restrict the lawyer's power, you defeat that whole purpose. You lose the safety net. So the conclusion is that public policy favors protecting the client's right to their own counsel's judgment.
And after analyzing all those elements, what was the court's final conclusion?
The court granted summary judgment for the Dwyers. The holding was clear. The attorney's disapproval terminated the contract. He didn't have to explain why, and there was no evidence of bad faith. The Dwyers were free to walk away.
That is a powerful ruling. It's almost startling how much power it gives the attorney. I want to synthesize this for our listeners. Can you consolidate this into a practical tool, a checklist?
Absolutely. We can boil this down to an attorney approval diagnostic checklist. If you're looking at one of these situations, just follow these 5 steps.
Okay, what's step 1?
First, identify the clause. Is there an express provision for attorney review? Sounds basic, but if it's not there, you're bound.
Step 2.
Check the timeline. Was disapproval sent within the strict window? In Indoe, it was 3 days. If the lawyer is on day 4, it's too late. The escape hatch is closed.
Step 3, the exclusions.
Right. Check the exclusions. Does the clause forbid disapproval based on price? If the lawyer's rejection letter says the price is too high, that rejection might be invalid. The smart lawyer just disapproves of the contract generally.
Got it. Step 4.
Apply the standard. If the objection is general or if the lawyer is silent on the reason, you apply the subjective standard. The attorney is the sole arbiter. They don't need to be reasonable.
And finally, step 5. The floor.
The good faith floor. The only way to fight a disapproval is to prove bad faith. That means proving the lawyer was being arbitrary or capricious.
And that difference between unreasonable and bad faith is everything. You can be unreasonably picky, and that's fine. You just can't be fraudulent.
Precisely. You're paying your lawyer to be picky. You're paying for their satisfaction. If the lawyer says, I don't like the indemnity clause, that might seem like nitpicking, but it's not bad faith. Bad faith would be the lawyer disapproving because the seller refused to pay them a bribe. That's the difference.
So what's the big takeaway here? For me, it sounds like in New Jersey law, your lawyer is basically your get-out-of-jail-free card as long as they act in good faith.
I think that's right. This case elevates the attorney from a mere technical advisor to a critical gatekeeper of the whole deal. The court made it clear. You are entitled to the judgment of your counsel, and that judgment is paramount.
It really makes you wonder about the agreement itself. Here's a thought to leave everyone with. If you're a seller and you sign a contract with this clause, are you really under contract? Or have you just given the buyer a 3-day option that their attorney can cancel at will?
That's the reality of it. Until that window closes, the deal is only as solid as the attorney's mood.
Something to think about before you celebrate that home sale. That's it for this deep dive. We'll see you on the next one.